Do you believe a freshman lawmaker could use just 27 words to upend the entire political career of the second most powerful man in America, built on the mantle of constitutional expert? That is exactly what happened. Seconds before the red light went on, Mike Johnson tightened his grip on a pen. The hearing room held its breath. He had just wrapped a polished lecture on original intent and separation of powers, smooth as a textbook. Then it was Jasmine Crockett's turn. No bluster, no slogans. She laid the groundwork with cold, dry bricks, principle, method, consistency, and finally, she drove the bit into the bullseye. If originalism is fixed, why did it take until 2008 District of Columbia v. Heller for the Supreme Court to recognize an individual right under the Second Amendment? In that moment, the loudest sounds were a page turning and a caught breath at the corner of Johnson's mouth. He invoked Scalia. Crockett pulled the room back to 1791, putting Militia precisely where the text places it. This was no longer a partisan shouting match. It was a test of method. Be consistent, or swap theories to fit the preferred outcome. In 5 tight minutes, a steel-cold argument pried up the gloss of confidence. The room did not applaud. It went still. The thick kind of silence that follows when a single question shakes the foundation. You're listening to Jasmine Crockett File. If this sharp, even-handed storytelling speaks to you, hit subscribe. So the next time Washington quakes over the right question, you're in the front row. Before entering politics, he had worked as a lawyer for the Alliance Defending Freedom, a conservative Christian legal advocacy organization. His rise to the speakership after the chaotic removal of his predecessor had been swift and surprising, with many attributing his selection to his reputation as a constitutional scholar who could navigate difficult legal questions facing the caucus. Since taking the gavel, Johnson had frequently cited his legal background when pushing controversial legislation. As a constitutional attorney for over 2 decades, he would begin using his credentials to add weight to his positions. He regularly appeared on cable news programs, where hosts introduced him as a constitutional expert whose legal analysis carried special authority. His office walls displayed framed copies of the Constitution and the Declaration of Independence, visual symbols of his self-proclaimed expertise. Congresswoman Jasmine Crockett presented a dramatically different background and approach. At 42, the freshman representative from Texas had joined Congress after serving in the Texas legislature. Before politics, she had built her reputation as a civil rights attorney, representing clients in police misconduct cases and fighting for voting rights. Where Johnson spoke of original intent and textualism, Crockett emphasized evolving interpretations and the lived reality of constitutional principles in practice. Today's hearing had been convened to examine Speaker Johnson's controversial legislative agenda, which Democrats argued violated several constitutional principles despite his claims of constitutional fidelity. Johnson had agreed to testify, confident in his ability to defend his positions based on his legal expertise. He had arrived with binders full of notes and historical references, prepared for what he expected to be standard partisan questioning. What Johnson apparently hadn't expected was that Crockett had spent the previous night meticulously researching his legal career, public statements, and voting record. While other Democrats planned to focus on policy disagreements, Crockett had identified something more fundamental, a striking contradiction between Johnson's stated constitutional philosophy and his actual legal positions. Over the years, the stakes extended far beyond a single congressional hearing. This was a battle over who had the authority to interpret the Constitution, whose legal expertise would be valued, and which vision of American governance would prevail in the public narrative. For Johnson, maintaining his image as a constitutional authority was crucial to his effectiveness as Speaker. For Crockett, exposing contradictions in his positions would undermine the very foundation of his political power. As Crockett arranged her notes, the committee room settled into expectant silence. Republican members looked relaxed, confident in the Speaker's ability to handle whatever questions came his way. Democratic members leaned forward, curious about their colleague's approach. None of them, not even Johnson himself, anticipated how thoroughly one carefully crafted question was about to change the dynamic of the entire hearing. Thank you, Mr. Chairman, Crockett began, her voice clear and measured. And thank you, Mr. Speaker, for appearing before the committee today. Before I ask my main question, I'd like to confirm a few points about your legal philosophy for the record. Johnson nodded confidently. Happy to clarify my positions, Congresswoman. You've described yourself as a constitutional originalist and textualist. Correct, Crockett asked. Yes, that's accurate, Johnson confirmed. I believe we must interpret the Constitution according to its original public meaning at the time it was ratified. And you've stated numerous times that the Constitution should not be treated as a living document that evolves with changing times and social values. Correct. That's right, Johnson replied, warming to a familiar topic. The Constitution has a fixed meaning. If changes are needed, they should come through the amendment process, not judicial reinterpretation. Crockett nodded, making a note. And would it be fair to say that you believe this originalist approach should be applied consistently to all parts of the Constitution? Absolutely, Johnson said with conviction. Consistency is essential to constitutional interpretation. We can't pick and choose which parts to follow based on political preference. With those preliminary questions, Crockett had established the foundation for what was about to come. Johnson had walked directly into her carefully set trap. Unaware that she was about to use his own words to completely dismantle his constitutional credibility. Thank you for those clarifications, Mr. Speaker, Crockett continued, her calm demeanor giving no hint of the bombshell she was about to drop. I have one substantive question for you today. She paused briefly, ensuring the C-SPAN cameras were focused on both her and Johnson, then delivered the question that would render the Speaker of the House speechless. Given your commitment to strict originalism, can you explain why you believe the Second Amendment protects an individual right to bear arms when the Supreme Court didn't interpret it that way until 2008 in District of Columbia v. Heller? More than 200 years after ratification, the hearing room fell completely silent. Several committee members blinked in surprise at the unexpected angle of attack. This wasn't the policy question Johnson had prepared for. It was a direct challenge to the consistency of his constitutional philosophy, using one of conservatives' most cherished positions on gun rights. Johnson stared at Crockett for a moment, his practiced smile faltering. He reached for his water glass, taking a sip as he visibly gathered his thoughts. Well, Congresswoman, the Heller decision simply recognized what was always true about the Second Amendment. The right to bear arms has always been an individual right. Crockett nodded thoughtfully. That's interesting, Mr. Speaker, because for most of American history, including the first 217 years after the Second Amendment was ratified, federal courts consistently ruled it protected a collective right related to militia service, not an individual right to own firearms for personal use. If you're an originalist, shouldn't you follow that original understanding? The question hit like a precision strike. Several Republican members shifted uncomfortably in their seats. This was challenging Johnson on terrain, where conservatives believed they had the strongest constitutional footing, using their own methodology against them. Johnson's response came more quickly this time, but with a noticeable defensive edge. The earlier courts got it wrong. The text is clear. The right of the people to keep and bear arms shall not be infringed. That's an individual right. So you believe courts can get it wrong for over 200 years about the original meaning of the Constitution? Crockett asked, her tone remaining conversational rather than confrontational. That seems to contradict originalist philosophy, which holds that the meaning was fixed at ratification and should be clear to those who study the historical record. She continued before Johnson could respond. And if we're looking at the text, as you suggest, the full Second Amendment reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The militia clause seems quite relevant to the original understanding. The committee room had grown increasingly tense. What had begun as a standard oversight hearing had transformed into a constitutional law seminar where the self-proclaimed expert was struggling to maintain consistency. Democratic members were now watching with undisguised interest, while several Republicans were frantically flipping through notes, hoping to find something that might help the speaker. Johnson straightened his tie, his earlier relaxed demeanor now replaced by visible tension. The militia clause is prefatory, not limiting. It announces a purpose without restricting the right. Justice Scalia explained this thoroughly in Heller. Yes, in 2008, Crockett noted calmly, but we're discussing the original understanding at the time of ratification. If originalism is correct, how could courts, legal scholars, and legislators misunderstand this supposedly clear individual right for over 2 centuries? Doesn't that contradict the core originalist claim that the Constitution's meaning is fixed and discernible? The trap was now fully sprung. If Johnson maintained that the Second Amendment had always protected an individual right despite centuries of contrary interpretation, he was undermining the originalist claim that constitutional meaning is clear and fixed. If he acknowledged that constitutional understanding can evolve, he was contradicting his fundamental legal philosophy. Either way, his carefully constructed image as a consistent constitutional authority was crumbling in real time. Johnson glanced toward Chairman Jordan, perhaps hoping for an intervention, but found none forthcoming. The chairman himself seemed unsure how to rescue the speaker from this unexpected constitutional dilemma. The historical record supports the individual right's interpretation when properly examined, Johnson finally said. Though his voice lacked its earlier confidence, the founders clearly intended, "I find that fascinating." Mr. Speaker, Crockett interjected smoothly, because in your own legal brief in Sylvester, Becerra, you wrote that constitutional rights must be interpreted in light of changing circumstances and evolving understandings. That sounds remarkably like the living constitutionalism you've repeatedly condemned. The committee room erupted in murmurs. Johnson's face visibly flushed as Crockett held up a printed copy of the brief he had authored. This was no longer just about the Second Amendment. It was about exposing a fundamental inconsistency in his entire constitutional approach. That statement was specific to the context of that case. Johnson responded, his voice now noticeably strained. My overall philosophy remains originalist. Does your originalism allow for evolving understandings when it supports gun rights, but not when it supports other rights? Crockett asked. That seems less like a consistent legal philosophy, and more like a selective application of different theories to achieve preferred outcomes. With that question, the dynamic of the hearing had completely transformed. What had begun as a standard committee session with the speaker confidently defending his agenda had become a masterclass in exposing constitutional inconsistency, using just one carefully crafted initial question and precise follow-ups. Crockett had forced Johnson to contradict himself repeatedly on his most fundamental claim to authority, his constitutional expertise. The tension in the hearing room was palpable as Mike Johnson struggled to regain his footing. His earlier confident demeanor had completely evaporated, replaced by visible discomfort. He shuffled through his notes, clearly searching for talking points that suddenly seemed inadequate for the constitutional trap he found himself caught in. Congresswoman. You're conflating different legal concepts, Johnson said, attempting to sound authoritative despite his obvious discomfort. Originalism doesn't deny that applications of constitutional principles might address new circumstances. It simply maintains that the underlying meaning remains fixed. Crockett nodded thoughtfully. I appreciate that clarification. So, would it be fair to say that you believe the Constitution's principles can be applied to circumstances the founders couldn't have anticipated? Yes, within reasonable boundaries, Johnson replied, seemingly relieved by the more general question. That's interesting, Crockett responded, because when the Supreme Court applied that exact approach to recognize privacy rights in Griswold, Veer, Connecticut, or equal protection for same-sex marriage in Obergefell-Vubby, Hodges, you condemn those decisions as judicial activism and living constitutionalism gone wild. Yet you celebrate when the same interpretive approach is applied to extend Second Amendment rights beyond what was recognized for most of American history. The committee room fell completely silent. Several Republican members looked down at their notes, visibly uncomfortable. Democratic colleagues tried to hide their surprise at the effectiveness of Crockett's approach. Rather than arguing policy positions, She was exposing a fundamental inconsistency in Johnson's entire legal philosophy. Those cases involved creating new rights not found in the text, Johnson countered, his voice taking on a defensive edge. The Second Amendment explicitly mentions the right to bear arms. The 14th Amendment explicitly mentions equal protection under the law. Crockett replied calmly, "Yet, when courts applied that text to protect same-sex couples, you called it activist judging. When courts applied the Second Amendment to protect individual gun ownership, a right not explicitly stated in the text and not recognized for over 200 years, you called it proper originalism? The inconsistency seems clear." The C-SPAN cameras caught Johnson loosening his tie slightly as beads of sweat became visible on his forehead. Chairman Jordan glanced at the clock, perhaps hoping to rescue the speaker, but Crockett still had over 2 minutes remaining in her allotted time. "Mr. Speaker," Crockett continued, her tone remaining professional and measured, "I'd like to enter into the record this 2019 speech where you stated the Constitution's meaning was fixed at the time of ratification and doesn't change with judicial fashion or political preference. Do you stand by that statement?" "Of course," Johnson replied, seemingly grateful for what appeared to be a softball question. Crockett nodded. "Then I'm struggling to understand your position on the Second Amendment. If the Constitution's meaning was fixed at ratification and doesn't change, how do you explain supporting an interpretation that wasn't recognized for over 2 centuries after ratification? Doesn't that contradict your own stated principle?" The trap had closed completely. Johnson found himself in an impossible position of his own making. If he maintained that the Second Amendment always protected an individual right despite centuries of contrary understanding, he was undermining the core originalist claim that constitutional meaning is clear and fixed. If he admitted that interpretations can evolve, he was contradicting his fundamental legal philosophy and opening the door to constitutional approaches he had spent his career condemning. "The historical evidence supports," Johnson began, but his voice trailed off as he seemed to recognize the corner he had backed himself into. "Mr. Speaker," Crockett said, her voice still composed but now carrying unmistakable authority. "Respectfully, what the evidence suggests is that you apply originalism when it leads to outcomes you prefer politically and abandon it when it doesn't. That's not constitutional fidelity, it's constitutional convenience." The gallery erupted in murmurs. Several journalists were frantically typing on their laptops, recognizing the historical significance of what they were witnessing. A freshman congresswoman had just systematically dismantled the constitutional credibility of the Speaker of the House using nothing but his own words and positions. Johnson's response, when it finally came, was telling in its weakness. "The courts have settled this matter. Heller is the law of the land." "Yes, it is," Crockett agreed. "Just as Obergefell is the law of the land regarding marriage equality, and Griswold is the law of the land regarding privacy rights. Yet you celebrate one while condemning the others, despite all three representing evolving interpretations of constitutional text. The difference appears to be not your legal philosophy, but your political preferences." She glanced at the chairman. "Mr. Chairman, I have no further questions. I'd like to enter into the record the Speaker's 2019 speech on originalism, his legal brief in Sylvester v. Becerra advocating for evolving understandings of constitutional rights, and his public statements condemning the Obergefell and Griswold decisions as judicial activism. Without objection," Chairman Jordan muttered, clearly eager to move on. As the clerk gathered Crockett's documents, the committee room remained unusually quiet. Republican members avoided making eye contact with the Speaker, while Democrats exchanged glances of barely contained amazement. Johnson himself sat stiffly in his chair. His earlier authoritative presence diminished. The constitutional expert had been exposed as constitutionally inconsistent by a freshman representative with one devastating question. The C-SPAN cameras captured it all. Johnson's confident entrance, Crockett's precise questioning, and the steady unraveling of the Speaker's credibility in real time, without raising her voice or making a single personal attack. Congresswoman Crockett had accomplished what countless partisan attacks had failed to do. She had challenged the very foundation of Johnson's authority, using nothing but his own words and principles. Within minutes of the exchange, clips began flooding social media platforms. Crockett question, Johnson stumped, and constitutional consistency became top trending topics nationally. The clip of Crockett asking her initial question about the Second Amendment and originalism had already reached over 1 million views on Twitter within the first hour. Political commentators across the spectrum scrambled to analyze what they had just witnessed. On CNN, a panel of legal experts dissected the exchange. What we just saw was a masterclass in constitutional cross-examination, said a former federal judge. Congresswoman Crockett identified the fundamental contradiction in the speaker's legal philosophy and exposed it with surgical precision. She didn't attack him personally or engage in partisan rhetoric. She simply used his own stated principles against him. MSNBC ran a Chiron reading. Speaker exposed, Johnson's constitutional contradictions laid bare. Even on Fox News, legal analysts struggled to defend the speaker's inconsistent positions. Johnson walked into a perfectly executed trap, admitted one conservative commentator. When you build your entire political brand around constitutional originalism, you can't apply it selectively without undermining your own credibility. As the hearing continued, Johnson's demeanor remained noticeably subdued. His responses to subsequent questions lacked the confident authority he had displayed earlier. Republican members attempted to throw him softball questions to help him recover, but the damage had been done. Every answer he gave now seemed tinged with the awareness that his constitutional methodology had been exposed as inconsistent. Outside the hearing room, journalists swarmed Crockett as she exited. "Congresswoman, did you anticipate the speaker would be unable to reconcile his positions?" One reporter called out. Crockett's response was measured and professional. "My job on the Judiciary Committee is to ask substantive questions about constitutional interpretation, especially when it forms the basis for legislative decisions affecting millions of Americans. Consistency in legal philosophy isn't a partisan issue. It's fundamental to the rule of law." Her refusal to gloat or frame the exchange in partisan terms only enhanced the impact of her questioning. This hadn't been a typical congressional gotcha moment. It had been a substantive exposure of constitutional contradictions by someone clearly fluent in the subject matter. The political fallout was immediate and far-reaching. Democratic leadership, recognizing the significance of the moment, began featuring clips of the exchange in their messaging about Johnson's speakership. How can someone lead the House when their most fundamental principles shift? Based on political convenience, asked the House Minority Leader in a press conference that afternoon. For Republican leadership, the damage control efforts began immediately. Johnson's office released a statement claiming that Crockett had taken the speaker's positions out of context in a partisan attempt to distract from substantive policy issues. But this defense rang hollow against the visual reality of Johnson's inability to reconcile his own contradictory statements when confronted with them directly. Constitutional law professors began incorporating the exchange into their teaching materials. Harvard Law School's professor of constitutional interpretation told the Washington Post, "This will become a textbook example of exposing inconsistent legal methodologies regardless of one's political positions." The exchange revealed a fundamental problem in contemporary constitutional discourse: the selective application of interpretive methods based on desired outcomes. The impact didn't stop at the edge of campus seminars. Conservative legal groups that had long showcased Mike Johnson as a constitutional authority suddenly faced a messaging problem. Several released carefully hedged statements reaffirming fidelity to originalism, pointedly omitting Johnson's name or the hearing itself. Even the Federalist Society, where Johnson had been a frequent presence, quietly pushed his upcoming appearance off the calendar. It wasn't a public rebuke, but the signal was unmistakable. The brand had taken on water. For Johnson, the damage landed where it hurt most, on the persona he'd built over years of media hits and conference keynotes. His effectiveness as speaker depended on the aura of constitutional mastery. After the exchange, that aura flickered. Each time he invoked originalism or constitutional fidelity, critics could point not to a partisan soundbite, but to a 5-minute sequence in which a single question revealed selective application of the very principles he championed. Coverage lingered for days, legal analysts across the spectrum weighed in. The New York Times framed it as when originalism meets political convenience, while the Wall Street Journal offered a gentler take, arguing that Johnson's position, though poorly delivered under pressure, reflected a more nuanced strand of originalism. But even sympathetic voices conceded the on-camera struggle to reconcile method with outcome. The footage was inescapable. Interpretation aside, the moment read as inconsistency. The clearest aftershock surfaced 2 weeks later at a press conference. Asked about constitutional issues and pending legislation, Johnson, once eager to teach from the podium, kept it brief and deferred to the Judiciary Committee chair. The shift was subtle but telling. The didactic certainty that had powered his brand gave way to hedged practicality, the rhetorical equivalent of stepping back from the lectern. For Jasmine Crockett, the arc bent in the opposite direction. National bookings multiplied. Law schools requested lectures on constitutional consistency. Democratic leadership spotlighted her performance in committee prep. Donors took notice. Back home, constituents hosted watch parties to replay the exchange with the pride of fans who discovered a breakout act before the rest of the country did. When Crockett finally sat for a long-form Sunday morning interview, her tone matched the hearing, measured, precise, and deliberately non-triumphal. This wasn't about partisanship, she said. It was about method. We can disagree on interpretive schools in good faith, but we should apply our chosen method consistently, or admit what's really driving the decision. Asked whether she'd engineered a trap, she offered a lawyer's shrug. Rigorous prep meets a public figure who built his identity on constitutional expertise, and identities should be tested. Academia took note. Political science and law courses began filing the exchange under case study rather than clip. It offered a clean template, establish principles, test for consistency, and measure the gap between doctrine and deployment. On the Hill, lawmakers in both parties grew more cautious about tossing off originalism or living Constitution without the scaffolding to defend the choice. 6 months on, Johnson appeared at a conservative legal conference and fielded the inevitable question. His answer was more careful, more footnoted, acknowledging that serious originalism requires historical work that can produce surprising results. It was a sturdier argument, intellectually defensible, politically less satisfying. The emphatic edges had softened. For Crockett, the legacy was broader than a viral moment. She demonstrated that substance, careful sourcing, disciplined questioning, control of tempo can puncture performance. Witnesses and members alike took the hint. When she adjusted the microphone, people opened their binders. In a town fluent in theater, the confrontation cut through as something rarer, method made visible. A single question didn't just challenge a speaker. It raised the floor of the conversation about how we read the Constitution in public life. Share your thoughts in the comments. I genuinely want to hear what resonates with our audience. And if you're into this kind of reporting, don't forget to like, share, subscribe, and tap the bell to catch more stories. Check out the featured video on your screen. It's a piece I'm especially proud of. Thanks for the support, and see you next time. Jasmine Crockett File.